Okay, welcome everybody. I'm glad to see. I hope we had mostly enough lunches to go around. No, never quite, but that's because we have such a big draw with us here today. It gives me just enormous pleasure to introduce my friend and former student, Viet Din. I met him as a first year student, first day, 8:30 in the morning, civil procedure, and I was calling off the seating chart, and I'd only been teaching a few years. I was still nervous. There were 150 people in the room. This was the less kinder, gentler Harvard Law School. And I'm looking on the seating chart, and I say, Miss Din, please state the case. There's like a little he says, well, actually, I'm Mr. Din. And from there, it's been magic ever since. So you didn't come to hear me, you came to hear him. He's had an absolutely incredible life and career, and I hope he tells you some of all of it. And it is with my great pleasure to introduce Viet.
Thank you very much, David. Thank you very much. And I want to introduce my son, Alexander, who's there doing what everybody does in my classroom, playing with his iPad. I think that today is Angry Birds, which is appropriate. Thank you very much for having me here, David. And thank you very much for the program on legal profession. I cannot think of a better program at a better place at a better time, because as you all know, we are in a bit of a flux, both here domestically and internationally, but more importantly, the legal profession, for good or for ill, is having profound effects on the development of civil law, the development of society throughout the world, or the lack thereof when we fall down on the job. And I know that David and his folks have devoted their entire life to studying not only the law but the profession that we all are part of and are so proud to be a part of. And that's partly why I wanted to take not any particular topic, not focus on a particular aspect of what we have done, but rather take a walk through the woods, if you will, as to why I think that it is a great profession to be a part of, and how it has allowed me at a personal level and many others at a general level to take full advantage of the gifts that God has given us, and also to do the most good that we can with those gifts. I started out as David's student, and from there my entire life was defined. What did David teach me in that first year and throughout my time here that was not only valuable but critical? First, be honest and be ethical. Two, be open to opportunities and challenges that come with those opportunities. And three, be flexible regarding your career path and your focus. Always focus, but also be flexible regarding opportunities that present themselves. When I first came out of law school and after the clerkships, my first thought was that I'm going to cash in on the bonus, and quickly was disabused of that short-term thinking and went into a rather long-term prospect of academia. And I was actually quite honest about my reason for going into academia, because I thought it was more entrepreneurial than to go into into the legal profession. That may sound a bit counterintuitive, to go into academia to be more entrepreneurial, but that's how I saw the risk-reward balance in academia. Everything you do is on your own chit. You have to sign every single article, and you are judged based upon your work and effort and the ideas that you generate and the arguments that you make. And by and large, there is a track, but it is a track that is permissive and not mandatory in order to advance. And most of what you do for your own advancement. And hopefully, if you do it well, you not only advance yourself, you also advance the entire legal profession and the understanding of the law. Contrast that with the traditional track at the time I faced the equation, which was 8-year up or out. and it's not only 8-year up or out, it's at, you are not considered to be up until the 8 years. There were some minor exceptions at small law firms at the time, but that was a fairly regimented track, and I thought that that may not reward the kind of the individual effort that redoubts to a person who is more entrepreneurial, and so from that germ was how I started the first career path into the academia, one that still defines me to this day, even though my interests are varied and my activities are multifaceted. When somebody asks me, what do you do? I say, I'm a law professor at Georgetown, and that's what defines me, that's what defines my life's work, because it is my first love and my primary love in the law, to ask the right questions, find the right answers, and engage in the process of enlightening ourselves and hopefully advancing the law. And academia provides you with really the best mechanism in order to commit to a life in the law. That life, of course, can take one many different places. I took a brief hiatus, the brief but meaningful, the hiatus to serve in the Department of Justice for 2 years. Still probably the most intense 2 years of my life, including the years I was clerking, although those were pretty close. Intense not only because of the job, but because of the nature of the times. I'd happened to straddle the 9/11 attacks on the American homeland, and so we were called to do a whole lot of things very quickly during that period, and the effects of which are still with us many years later. And so I am eternally grateful for that opportunity to serve, an opportunity which would not have been afforded had I not made a serious commitment to the law and to legal academia. Which reminds me of a piece of advice that somebody, I think it was Ron Olson, who's the former head of California Bar's named partner in that great law firm Munger, Tolson, Olson out in L.A., where he told me, he said, Viet, career development is kind of like a mushroom. I said, maybe too California for my taste. Can you hum a few bars and explain? And he said, you know, you got to build a very strong stock. You know, just whatever you do, focus on building a very strong stock, make a commitment to developing yourself, developing your professional capability. In my case, it was constitutional law and academia. Focus on that. And then at the right time, when you have developed that strong stock, people will come to you, recognize it, and come to you for advice outside of that core competence into the cap of the mushroom. And that's exactly how it happened. Had I not been given the opportunity in academia, I would not have had the opportunity to serve in government. And so it was after I returned to academia that I continue my work there. I also started the third leg of the journey is the small little firm that we call Bancroft for the street that my wife and I lived on, and it started out really as an adjunct to my academic work because especially after we left the government, there was an increasing demand for consulting services, and I thought that doing it, giving into those demands, which was very tempting, especially with a young family, never having made any money, and deliberately leaving money on the table and not going the corporate route. It was very tempting, but that would also detract from my primary love and commitment to academia. And so we established a little infrastructure of 3 or 4 lawyers in order to allow us the ability to take on those projects when the demand is there, so that I don't have to do the work of an associate, and then I would be freed up in order to supervise that work, while at the same time make a primary commitment to academia. It grew, and at one point I think we were up to about 10 lawyers. with a fairly significant infrastructure. That also had a separate management infrastructure, so that I would not have to devote so much time and commit so much resources to it. And that's where we were until last year, when, among other things, serendipity brought three of us best friends sitting around a room like this when we're all in law schools. We were all friends. We all met each other in law school. Chris Bartolomucci, who was then a leader in Hogan Lovells appellate group, and Paul Clement, who was then the head of appellate at King and Spalding. And serendipity brought us all together. We're a godfather to each other's children. We've been best friends since law school. We went into the administration together. We came out of the administration together. We've never done any career moves without consulting each other. And we were brought back together last year. And where we are right now at Bancroft, which is still a very small boutique law firm, we are at 15 lawyers. And of those 15 lawyers, 8 were Supreme Court clerks. We have 14 appellate clerkships and 2 district court clerkships, and 7 presidential appointments. Fairly unique set of lawyers. We like to say that we are boutique, not because we're small, but we're boutique because we're very specialized in what we do. And most of that is Paul's. He has a couple of cases in the Supreme Court last term, and Chris also does a lot of appellate litigation. Where it all comes down to, going back to David Wilkins' influence, is that we're also, aside from the sexy litigation that we do, we are also called on to essentially serve as general counsels for public corporations, either on a specialized basis or in a general basis. Our firm actually does serve as publicly listed official general counsels for publicly listed companies, as well as taking on special projects where there are conflicts or specialized demands on the board or on the company. All of which is to say that we have ventured somewhat outside our zone of the initial comfort, but all of which we are very welcome to it, because we have been building a very strong base. So I think with that, I'd love to answer any questions that you may have. I've done a couple of controversial things in my life. Please don't hold back, because one of the skills that David has taught me very well is the ability to face hard situations, have hard conversations, make the hard decisions, and still be friends and live with each other afterwards. It's a loaded question because controversial is a loaded topic, right? How much controversy is a particular decision is or a particular activity is in the eye of the beholder, and how much noise there is in terms of the press coverage. I think it's and they don't necessarily map up to what is a more salient question, which is what are some of the hardest decisions one has to make, and so and I think there's a disconnect between of necessity, the disconnect between difficulty of decision and controversy of results. Like it or not, and in many ways I don't like it. If I die today or 50 years from now, on my tombstone will be Architect of the USA Patriot Act. Which was completely sort of like, which has been the moniker that I've been tagged with. First of all, I don't think you need an architect for a piece of legislation, and I don't know exactly what that means. It was basically that our office found itself in the place where the president asked us to look at all the laws after 9/11 to make sure that they are robust and modern enough, and for us to prosecute the war in the short term and win it in the long term. And we did that. We did that open-eyed, and we knew there would be controversy involved in it. We were comfortable in our legal analysis. Not a single provision has been invalidated for unconstitutionality. And I think the reason why it's become controversial, despite the fact that the bipartisan Congresses have reaffirmed and recommitted itself to it in successive times by unanimous, if not supermajorities, is the fact that the moniker USA Patriot Act has been taken not to reflect just the 50 provisions that we put in the original proposal, but almost everything, to reflect everything that was done in the name of the war on terror. And so you can think of enemy detention, you can think of waterboarding, you can think of terrorist the surveillance program, none of which have anything to do with the USA Patriot Act, but in the larger public imagination is all lumped into that one single moniker. So people are very surprised when I tell them that not a single provision of the USA Patriot Act has ever been invalidated for unconstitutionality, has been upheld, and some lower courts have and then been reversed. And none of it has to do with any of the controversies that you see. And indeed, every single provision that has been up for reauthorization has been reauthorized either overwhelmingly or in most cases unanimously by bipartisan Congresses. And people start, the controversy starts narrowing itself down into actual fact. And so, that's part of the public engagement process that I think that is very, very, very valuable. I like to say, just do great work, and yes, trees do fall in the forest, and yes, people do notice. No, but that's essentially what we do. It's kind of a cheat of an answer because all three of us had very prominent careers prior to coming to the firm together, and certainly people call me initially because of they needed issues to be solved in national security or in those areas, and they find out that we can solve other problems. People go to Paul obviously because he's the best advocate of his generation, and that gets around. And Chris Bartolomucci likewise had a firm base at a major large law firm, and so we had that client base. We bring it all to us, but that only answers the first phone call, right? And especially in a world unlike my side of the ledger, which is continuing corporate work. On Paul's side of the ledger, it's single one-off work. You only have one appeal. Hopefully, you only have one appeal an entire career that goes to the Supreme Court. And when you do, you call Paul, and then after that, you just say, "Hey, I had a case that went to the Supreme Court," and then Paul goes out and has to try to generate another 10 cases for the next year. And so those are all one-off works, and it has to be by reputation. It has to be absolutely by reputation. And reputation can only be developed by consistency of work. And that's why the bench that we have built is so deep. Each and every single one of our lawyers can stand up and argue a Supreme Court case, and I have absolute confidence in it. And that's essentially our test. It's not whether you can do it or not. It's just simply when are you handed the opportunity to do it. And we would because there's no other way to do our work. And so people recognize that. That means that we just have to hire the best and insist on very quality work product and gets completely integrated. And so that one client becomes, next time they have an appellate issue, will call us again, and we expand. The Supreme Court work is the sexy part, but that's not really the part of the work that sustains the firm. All the other aspects that goes with running a firm, like appellate litigation at the circuit court level, like district court litigation and the motion to dismiss level, those are the things that pay the bill. And the sustained, continuing corporate work on my side of the ledger, the ones that are important to the P&L of a law firm. But like anything else, it requires good branding, and good branding requires good reputation. And the only way that I know to build good reputation is by delivering a quality work product consistently. And we have a bit of a saying at Bancroft also. We do work that many big firms cannot do because of the consistency of our team. And also sort of almost intense dedication that we have to the place. We got a call maybe 10 days ago for somebody who wants to bring a challenge, first challenge ever to controversial national security regime. We filed a suit last week, but we got a call 10 days on a Friday asking whether or not we can do a full analysis of the viability of a lawsuit by Monday, because they had to make it, their negotiations broke down. They have to decide on Tuesday whether or not to launch the first ever challenge to the Committee on Foreign Investments in the United States. And and right in the middle of a trade war, Chinese client, this is high level stuff, but it's also fairly intense stuff. We just did what I call a swarm. We called in 5 associates, and all 3 partners got engaged, rolled up their sleeves over the weekend, and delivered a 30-page assessment memo and proceeded. That's the kind of stuff that very few law firms can do, large or small. It's just that when we're small, we tend to get more excited about things, and we do, especially about the opportunity to do the path-breaking work, and so we swarm. And this is after that entire team had just finished a 6-month and 5-day trial on first ever trial we've ever done, but it's on the constitutionality of Voter ID Act in South Carolina, and so that entire team, who just completely exhausted, we just took and plopped into a different case. But I think that's the advantage we have as being small. The disadvantage, of course, is scope. We just don't have the bodies to do a massive district court litigation, and the other disadvantage is that is in terms of balance sheet and profitability, we don't have our ability to cross sell. And so, in order to sustain our work, we're not. Our business model is not a traditional appellate firm business model, which is to discount our work in order to get marquee value in order to cross sell the corporate work. We have to go the other way. We generally charge higher rates than normal law firms because we don't have the cross subsidization of massive numbers of first or second year associates in order to do document review or the sort of the regular corporate work. My mom had this test. She still does. She's still with us, and I'm not sure she applies the test anymore. Now we're all grown. She said it's the get out of bed test. If you wake up one morning and you decided you really don't want to get out of bed, that's okay. That's just you being lazy. But if that happens for a week, you got to start asking questions. If that happens for a month, you have to start looking for answers. And that's a fairly straightforward test that gives very clear guidelines. At what point is this no longer malaise, and at what point does it translate into actual action? And I just keep that, 1 day, 1 week, 1 month. And I just remember that, and part of the and that's on the downside. On the upside, I asked the exact same question that you asked of me, which is of all the opportunities, how do they compare? In many ways, the being where I was at Office of Legal Policy is quite similar to where I am at Bancroft, mostly because of size and focus. The Office of Legal Policy is a small 30-lawyer group. And Bancroft is, is 15, but we'll grow to 20 by the end of the year. So it's the same kind of level of focus. And we ran Office of Legal Policy as the Department of Justice's think tank. And so we did a lot of creative work. I call it crazy ideas. Sessions and driving them toward fully blown policy proposals that ultimately get signed by the president or passed by the Congress. Just like we do at Bancroft, we take a case, Greenfield, and we analyze the heck out of it. We think through every single angle, and then we say this is the path to the W, and then we implement the heck out of it in order to get it to the W for the client. And so the work is fairly similar. Even before we made this big push into appellate litigation over the last 2 years, what we did was exactly that, but on a problem-solving basis. The client comes to us with a complex problem that's most of the time multi-jurisdictional, multinational, multidisciplinary, and we think it all through. We bring together and get a path to the resolution and hire the team around it. In order to do that. I think that's very similar and very rewarding in the sense that you have a dedicated team of professionals who are operating at the highest level, but who have resources we can call in order to effectuate the work that we devise. And that brings a certain esprit de corps that is very, very good to manage, that's very, very pleasant to manage, and very rewarding to lead. Because everybody feels good as part of the exercise, not because you're trying to pull teeth, trying to get people to do something. I'm not very much of a manager, nor am I a very big sort of inspirer. I'd like to think that the work that we do is an indication of the commitment that we have and the interest we have in in the work as well as the work product. And if we can find the work and the work product that inspires everybody, then the leadership and the management task becomes much easier, and you don't have to break heads, you don't have to fire people, you don't have to over incentivize or under incentivize. They do it themselves. They self-select, and we all share in the rewards and share in the misery. And so those two compares very well. And fortunately, as I describe Office of Legal Policy, it's quite similar to applied academia. Right? The first time I ever set foot in the Department of Justice was to interview for the job. And that was also the first time I met John Ashcroft. So I got to tell you a story. I got to tell you the story. I'm sitting there in my office. This whole 2000 election, you may have remembered, all came down to last minute kind of the kind of litigations. Everybody's transfixed, all this stuff. And I get a phone call. This is in January, after all is done. I get a phone call. It says, so-and-so is from the White House Transition Office. And I said, you're joking me. It's like, no, really, I am. I was like, there's a lot of this phishing scams going around, going to get your personal information. How did I know you are who you are? And they said, well, I'll give you a phone number, and you can call back. And they gave me the phone number, the main phone number. I called back, and they got transferred. I said, okay, now you established your bona fides. What do you want? It says, we were wondering if you're interested in considering a division of the Department of Justice to run, like the Office of Civil Rights Division. And I said, I'm not interested, not qualified, don't know much about that area of the law, but thank you very much for thinking of me. And I got a call back saying, about half an hour later, it's like, we respect that, but what would you like to do? I said, there's this little office called Office of Legal Policy. He said, Office of Legal Policy, Office of Policy Development at the time, run by L.D. Atchison, a very, very good lawyer. And but yeah, small little shop, and they asked why I was interested, and I said because it's kind of like I like to make it a think tank for the Department of Justice, and that's exactly what I said to John Ashcroft. I said to John Ashcroft, he says, why do you want this little backwater office? I thought you would go for OLC. And I said, no, too many people fighting for OLC. I'd like to create my own green ocean. And so he says, that's exactly what I wanted. The art of leadership, the definition of leadership is a redefinition of the possible. I want you to run legal policy as a think tank. And generate crazy ideas, vet them, bring them up so that we can make decisions, and that was very rewarding for a recovering academic like me to hear. So all of that compares fairly well. I think that academia is lonely. It is probably the most monastic because you don't have a team around you. Not every one of us can be like David Wilkins, where you have this beautiful team and mini empire going on here. But that's probably more monastic and more cerebral, as you would expect. Private practice is much more profit driven. At the end of the day, I'm responsible for a staff of 30. And if I mess up on my math, you've got 30 people who don't get paid. And you start to monomaniacally get focused at everybody. You have to meet payroll and plan all of that. Alexander has to go to private school and things like that. And that weight of responsibility is real because you're responsible not only for a balance sheet and a P&L, but for somebody's livelihood and their food on the table. And that's much more intense, and you have to focus on the profit motive. As much as we like to do a lot of pro bono work, also. So then the government, I do not subscribe to the usual poo-pooing of government service, and especially of government servants. I actually do think that people who enter government service do so for very noble and enlightened reasons. And if there is fault in the structure, it is up to the leaders in order to create the preconditions for the work satisfaction and inspiration that is necessary to make that kind of work inspiring and and meaningful. Nobody goes through life saying, I want to be a bureaucrat. Right? Nobody wants to go through life saying, yeah, I want to be coddled. Nobody wants to go through life saying, yeah, I just want to be a cog in the machine and make it really, really miserable for everybody else. And all I want to do is just soak up the federal budget in order to get my share of the taxpayers' pie. This is a great gig. Nobody does that. It's just, it's the fault of leadership if that's what you think. Is wrong. It's from the macro to the micro, because I've never met anybody who says, oh yeah, people in my unit are complete ne'er-do-wells and all they want to do is punch a clock and make life miserable for people. Nobody wakes up in the morning and do that, right? So. Not much different, to be perfectly honest with you. Not much different. The key there is just you can't bend either way. You have to recognize the threat as real or imagined, and if the threat is real, you have to come up with the right solutions. And if it's imagined, you brush it out. I mean, most of the arguments regarding the credibility of threat, real or imagined, and then the making the solutions fit. And so in many ways, the transition from national security decision maker to national security advocate, I would contend, is actually much easier than the traditional prosecutor defense lawyer jump. Because that's a dramatic, that's on the different sides of the V, right? And the thing that holds that equation together traditionally is the V, the respect in the process and the adversarial nature of our legal process, and that's what holds it together, because the two sides of the V are almost diametrically opposed. Both in terms of structure, in terms of tactics, in terms of how you approach the case. The only glue is their familiarity of what goes inside the V, which is the courtroom process. Whereas the national security, I think, if you approach it as that, I think you have lost as an advocate and have not done your job as an official. Because again, unless you assume that advocates are part of the counterintelligence or terrorist problem, in which case we shouldn't have. You should go ahead and waterboard. But you'll run out of space pretty quickly because you can have to waterboard the entire ABA. But the
Some have recommended.
now. In the national security field, I think that there's this sort of general sense that we're all in it together, and there will be differences in terms of application, certainly in terms of emphasis, but there isn't much sort of like quote unquote political ideological difference, because we're all in many ways it's the national security professionals versus everybody else. And so you kind of the way of practice is much easier in that regard. It does carry with it some dangers. Somebody, a much wiser person, much more experienced person than I was, pulled me aside and told me about this right around 9/11. Says one of the dangers of being on the side of a national security professional is this, what he called national security tunnel vision. You tend to think that, gee, I'm the only one who have access to the intel. I'm the only one who's faced with this life and death decision. I'm the only one who knows both the facts and the consequences. So therefore, I'm the only person who can make this decision. And you tend to get tunnel vision into it, and that's just a dangerous place to be as a decision maker, because you are blinding yourself from the facts, not willfully. But just structurally, you're making imperfect decisions, and then worst of all, you're rationalizing those imperfect decisions, and do not take advantage of ways for improvement. The nice thing is that I think most everybody are self-actualized enough; they recognize when they have that, and so a big part of being a national security advocate on the outside is to guide the official decision makers into different sources of information, different ways of looking at it, and different perspective, knowing that if you were in their position, you would probably do the exact same things and would want the exact same sources and differences.
preference?
No, yeah, yeah. So the answer to the second question answers the necessarily the obvious the need to answer the third question, right? It is not a matter of personal preference. It's not a matter of strategic decision. All three of us are obviously Republicans. We're not going to run away from that. It's not and we're not the only. We're not a firm made up only of Republicans. One of the nice glint in my eye moment this last year was that we are one of the sponsors of the American Constitution Society's annual convention. Letting everybody to Google, what? What's going on? But that came about because Kelsey Corcoran, who is working for us, coming out, who worked in the Obama White House and argued 28 cases as part of the Civil Appellate Division, who clerked for Judge Taylor and will clerk for Justice Ginsburg. Somebody from ACS approached her and says, "Will Bancroft sponsor this?" And my response was like, "Of course we'll sponsor this, but does ACS actually want our money?" And to their credit, we asked the question back, saying, "Yep, we thought about it, and this is a deliberate ask." And I said, "Great." And so I'm glad to see the reputational market is working because there is that perception out there that is grounded in facts. We do have the run of conservative cases. There's no question about that. We had the Texas redistricting case last year where we got the call on Thanksgiving Friday, and by January 9th, we had a unanimous decision by the Supreme Court reversing the lower court decision, right? The most fastest breakneck the Supreme Court litigation we've ever done. And we have the South Carolina case, we had the Arizona case, we had healthcare, we had all the big cases last year, all three big political cases, Texas, Arizona, and Florida. We had them, and so we did have the run of the conservative cases, but that doesn't mean that we only do conservative cases. Most of our work is in non-political cases. That's how we get paid. It's also important to note that we do not take the political cases on a discount. We treat them exactly as we treat other cases. We do have a government rate, a blended government rate for government rates that reflects our blended rate for all of our lawyers, rather than separating out individually what we each charge. And it is designed and and operates as a full freight rate. And I watch that very, very carefully and calibrate it to make sure that we end up charging full freight depending on the staffing. But it differs. It doesn't differ because of the nature of the case or the level of government we just charge. I think our current rate is $650 blended for all government work. But it doesn't define us both in what we do, but more importantly in the cases that we take, even in controversial topics. So last year, at one point, I called Paul the most unpopular person in the entire world. Why? In 1 week, he convinced the Supreme Court to let free 40,000 California prisoners because of overcrowding. He represented the class in bond. He convinced the D.C. Circuit to uphold the Postal Service increase of stamp hikes, stamp rates from a quarter to 50 cents, whatever it is, or whatever it is today. And he entered appearance in the DOMA cases. Right, and so I was kind of like, I said, if it's just like if you pick cases depending on what you think is more popular, he has the trifecta of the wrong decisions. Because there's no Venn diagram that captures anybody that would be in favor of his choice of those three cases. And so, and Paul and his all shucks Wisconsin world would just say, if you do your job right as a lawyer, you're gonna hack people off sometimes. But at the same time, that run of cases shows, he also represented on a pro bono basis a woman who was sentenced to 30 years or some obscene amount of time for getting to a lover spat and putting a chemical residue on her boyfriend's lover's car. Understand it's crime, all that stuff, but it was charged with a chemical weapons treaty violation. It was charged charged as a terrorist and got 30 years in jail. It's like, wow, that makes that astronauts, the road across the country in a diaper look easy. But Paul took that on. He's still all part of that case. But we try to challenge, correct the record in that regard. But at some point, you also say, we are lawyers. We do what we do. We don't choose our clients, and we will give whatever clients our full commitment and work. Yeah, and that's why we're boutique. I mean, a major general services law firm can't have that kind of cavalier attitude because business conflict is so great. As a general counsel for public companies, I will ask the questions. I was like, who else are you representing? And try to make that business decision whether or not to hire. Whereas if I truly need the expertise that comes with a boutique firm, then I'm willing to answer that question. It's like these guys don't define themselves as such. They don't take on the opprobrium of their clients and the like. But as a general services law firm, that's very hard because and we will object as an ideological matter to our clients the posing business conflicts on us. And we just say, hey, if that's what you think of us, we're probably not the right guys. We're only, we are by definition single shot players. And if you have single shots, we'll do it, and we won't. Other clients' business conflicts won't infringe on our ability to do your work, but at the same time, we want reciprocity. And so that's why you see a little bit. I mean, I'm sure that the program has done a lot of work on this. You tend to see at the levels of the profession and the services we're talking about. You get these mega firms whereby a general counsel can pick up a phone to any partner anywhere around the world and get any task done anywhere around the world because it's just easy. It's done. As a general counsel, I value that very, very much. To extraordinarily small and specialized boutiques or practices whereby if you need the world's best in something, you don't care what you pay, and you don't care where they work, and you just simply go to that person. Yeah, and I'm glad for the question because I don't want to be misunderstood. I'm not an advocate of early and specialization and often specialization. I do think that one of the great advantages of the profession as a profession is that it accommodates and rewards generalists. Because we're one of the few professions that our judgment is really a stock and trade. We don't control access to capital. We don't control a big balance sheet. We don't, we're not chokeholds on anything, as it were. Unlike real estate brokers, unlike stockbrokers, unlike the bankers. In many ways, you look around the world of business. The way you make money is you have a chokehold on some sort of flow in a needed commodity. We don't have that, and to the extent that we have it, it's about access to the bar, access to the profession. But within the profession itself, the value we have in trade is our judgment and our ability. So in many ways, we are called upon to be generalists as a profession. I know the pressures toward specialization and the like. I would say that there is enough pressure and inherent drive towards specialization that you don't need to focus more or pay additional attention to it. I think if anything, you should resist the other way. That is, there will always be opportunities for you to specialize because if you do one job well, you're going to get a similar job and a third job and a fourth job. And then that's how specialization happens. Next thing you know, you're talking heads asking, how did I become a specialist in X, Y, and Z, all this stuff. And because you're very good at what you do, and people tend to come to you for what you're good at you do. At some point, during that process, you always have to ask yourself, am I being pigeonholed, hyper specialized, or am I getting enough professional development? Am I enjoying myself enough? And chances are you are. So I don't mean to say don't go overboard the other way. Just find the right balance and find that that sense that you are doing something that is much bigger than just simply the very, very small specialization. And that's also a good place for me to end by recounting a fable that my great uncle who's like my grandfather because my grandparents passed away early, and my great uncle was a Catholic priest, and we used to go visit him every summer, and he would just and every summer he would just remind us of this. He told a story about two construction workers, the two construction workers at his construction site, and their little boy, probably around the age of Alexander, when he told me, he said, your age, comes across this construction site and asks the first construction worker, what is it that you're doing? And the man says, what does it look like I'm doing? I'm digging a ditch. And it's adequate, the answer, perfectly accurate the answer, but somehow unsatisfying to a young person like Alexander. So he went to the next person and said, excuse me, sir, what is it that you are doing? To which the construction worker says, what are you, a wise guy? What does it look like I'm doing? I'm laying bricks. Again, perfectly accurate, but somehow unsatisfying. And so our young friend went to the third construction worker and asked, excuse me, what is it that you are doing? To which he got the answer, isn't it obvious? He looks down at the ground, looks out at the empty space above him, and says, isn't it obvious? I'm building a cathedral. Right? The exact same work, digging ditches, laying bricks, and the third person had the benefit of vision that redounds to his advantage, that I would argue the first two to their detriment. We do the exact same work, and yet if we have the sense of perspective and a sense of vision as to where it all leads, we will find the necessary skills in order to be the architect of that greater cathedral rather than simply being ditch diggers or the bricklayers for the rest of our lives. And I think that's what the foundations that we have here, certainly at the law school here, but also as members of the legal profession, allows us to do not only the skills, but also the luxury of vision and perspective. And it's an awesome responsibility, but you're gonna have to use it to build something. And it might as well be a very, very grand cathedral. We actually actively recruit out. We weed out folks who are coming off clerkship and says, can I do this for 2 years and explore government service or academia? And I said, hey, if that's where you end up, ultimately your career, we will not stop you from there or discourage you. But if that's where you are heading right now, ours is not the place for it. There's a couple of firms with much deeper balance sheets who actually will get the advertising value out of having Supreme Court clerks who are willing to pay you that obnoxious signing bonus for a couple of years as advertising value. We're not it. We're not it. We don't have the balance sheet. We don't have the patience. We don't. We need to build a community of sustainable professionals. And so our advice is clearly stay here for the long haul. And the question becomes, okay, great. What's in it for us? When is there a path? When is there a path, and how is it going to go? And I go back right to how Paul and I thought about it, and to a lesser extent, Chris thought about it. It's exactly that. So we don't have a 8-year up or out, or 8-year plus 2 years of non-equity partners, and then up or out. We just say there is no track, and you think you need a track. Probably this is not a place for you. We're that entrepreneurial. And they said, well, that basically means that you're just there in order to soak us until you can't soak us anymore. We're saying, no, here's the track. The moment that you can convince us that you will make more money for us as a partner rather than as associate, we will make you a partner. It is a perfectly honest, totally rational, and utterly, completely economic decision. Can you make us more money as a partner than as an associate? Right? If you can, then we will be irrational not to make you a partner, regardless how old you are, regardless where you are. Right? And if you cannot, then it seems to be a bit of a stretch to ask us to go out of pocket from Alexander's pocket to put in your pocket. Right? Why do I need to do that? Right? And so it's but that equation goes into it. A whole kinds of things. What substitutes are there for you in the market as me as a buyer, right? What alternatives are there for you as a seller of services? How well are we making the environment for everybody, and how well are we empowering you to develop the skills necessary to make you more profitable as a partner? And so we and that's exactly the answer that we give. We have a couple of folks who I think that are fairly ready in that regard, and we're ready to have that conversation if and when they may have it. And it has just completely honestly, it has nothing to do with how far up the ladder they are. Because we run a system whereby a third-year associate can be team leader on a case, and therefore can have call on the time of an 8th-year counsel, a 9th-year counsel, or even call on my time as a partner, just because the team needs it. And so we basically just ask fairly straightforward a management question: who owns this case? Who owns this decision? And whoever owns the particular case or matter or decision gets to make the call on resources in order to do whatever is necessary. And so it's a fairly team-centric approach, and of necessity a fairly flat organization with 3 partners. You're right. You're absolutely right. Nothing we can get away from that. We own everything, but we spread it around. It's an expensive bonus. It's always a risk, and you have to ask yourself. You have to ask yourself 2 questions. One, what is the probability, right? And then what is the upside versus what's the downside of all the eventualities? And how I approach it is that there's always a risk. There's of all 3 of us leaving for some administration job, and it goes from the probability goes from Paul to Chris to me. I'm probably the last one standing because it's Alexander. Again, there are real material costs to it, but you have to assess that probability, and then you say, okay, great. Whatever the probability, what is the actual the outcome, right? And I said, at absolute worst, all 3 of us go in. You will have spent X number of years being part of an experiment. That is unique in its kind, whereby everybody's committed to the same mission. Nobody will ever fault you for. Indeed, they will only applaud you for the work that you've done during that time. And if I can deliver that promise, it should be an easy question for you to answer. That your resume would not be adversely affected. It will only be heightened by it, and your professional development will only be heightened by it because of the unique experiment that we are running. That risk adheres, by the way, not just in small boutique firms. We're unique in that regard. I mean, we're sort of sui generis in that regard. I mean, I guess Klein Farm Toronto was an earlier experiment. But that risk runs at large firms too, because in many ways, large firms is an amalgamation of little practice groups. The best large firms have been able to transcend that. Places like Skadden, I think places like Jones Day, there are places that have sort of like established procedures and processes and brands that are transcendent of individual practice areas. But by and large, even those firms have practice areas that are dependent upon certain lawyers. And then everybody else working for that. And you see that at Dewey, Ballantyne, and other more celebrated or less celebrated cases. And so that attaches to, I mean, I've seen a lot of folks saying, well, I'm going to X because even if Miss So-and-so leaves, there's always going to be X. Well, when Miss So-and-so leaves, her little minions, unless she takes them with her, her little minions are kind of like castaways in this little, kind of soulless corporate world. And you get 6 months in order to find a new place, or not much else. You can sit there and so there is that risk. And so it's one that you should be very attentive to, especially as a junior at a junior level. What I say is that and the way we run Bancroft is we are a family, and we will not hire you into the family unless we like you. And for better or for worse, once you're in the family, you're always in the family. It's not a coincidence that of the current crop coming out of the Supreme Court, we've given offers to 3, and 2 of them were former employees of Bancroft. They started out as administrative assistants, they started out as paralegals and all that stuff, and went on to law school, got great clerkships, went on to Supreme Court clerkship, and comes back because we hired, even at the administrative assistant level, we hire and inspire with people whom we think is the best, and empower them and get them back into the fold, because the loyalty goes both ways. And that's something that we, that we are very proud of, and hope to encourage, going on for the next 60 years. But it's hard. We're now at 15. After 25, it's kind of hard for me to make that same commitment, right? I mean, I remember I was at Munger, Tolles & Olson before they had their 100th lawyer. And I just remember it was, once you go over 100, it's like, this feels a little bit different. And so we're all dreading that number 25. Yeah.
So get in while you can, and I promise you the rewards will outweigh the risk.